Good morning. Thank you, Kent. I've often complained to Kent about the coalition. I know they do great things, but I get pretty upset with them because they only ask me the hard questions. They seem to, and Kent handles a lot of the questions out there. The coalition, they do a great job for producers, and I enjoy working with them, but he never calls and asks me the easy questions. But we work through them, and again, glad to have you here today. Hope most of you didn't have a challenge getting here with roads and the weather, but if you did, we're glad we're here. Also, this will be on the internet, of course, and so those that couldn't make it, we'll have that available for them. I'll start by saying a couple of things. One, there are handouts at the back of the room with the slides that I'll be presenting with. If you didn't get one, raise your hand, and somebody will get you one. It looks like everybody grabbed one. I'll be going through those slides pretty much in order. We're going to start with talking about new DNR regulations that went into effect in mid-December. Not a lot of fanfare with these regulations, as we do have sometimes, but there are some things in there that you need to be aware of for confinement feeding operations and also for open feedlots. We'll talk about those first. Then we'll talk about winter manure application. Hope we don't have to deal with that much, but I always like to talk about that at the Pork Congress here. We have specific rules, as many of you know. We'll go over those a little bit. Talk about the DNR work plan inspections, how those are going. We're into, our fourth year now, out of a 5-year plan. And at this point, I always do this to him, and I'm going to do it today. We have Gene Tinker in the room here and Jeff Preer this year with the Iowa DNR. Raise your hands, guys. They're in the back of the room, and I will pick on them at various times through this presentation today because they never pick on me, believe me. All right. Yeah, they're ganging up on me. So I'll probably turn to them when we get to the work plan discussion. And then, I'm going from memory here, what's in the slides. I want to talk some about separation distance waivers. Have had some issues here this last year as we do at various times. Those of you that work with siting confinement buildings know that waivers are allowed. You can waive the separation distance if you're a neighbor. We have some DNR rules there, but we have some more legal lawyer rules, I'll call them, on how waivers have to be done, and we've had some issues with those getting done correctly. And if not, later the neighbor may question the waiver, whether they knew what they were signing, etc. We'll talk about that. Talk about animal capacity. We've talked about that for several years, how to calculate that. Talk about one site or two, common ownership and management. That's always a hot topic. And then we'll get into some lawsuits. We'll talk about the Des Moines Water Works lawsuit, maybe not a direct issue for DNR regulation and nuisance suits, but it's something that, of course, has received a lot of attention over the last couple of years now, and we're waiting on a decision. We'll talk about that. And then nuisance lawsuits. We'll finish up with that, and also air emissions reporting under the DNR and EPA requirements. There. How's that for, it took 5 minutes to tell you what we're going to talk about over the next hour and remaining 10 minutes. And as usual, we have a good-sized group here. If you have a question as we're going through something, please feel free to ask it as we go. I will repeat your question so we can get it on the make sure it's on the version that's going on the internet so people can hear it. And then secondly, I'm always around afterwards. I enjoy being around Pork Congress. I'll be here at various times today and tomorrow. If you don't get a chance to ask a question during the presentation and want to talk to me, I'll be glad to visit with you. And if you turn your name tag around when you talk to me, I won't know where to send the bill to. So just kidding. I will find out. No, be glad to talk to you, okay? All right, with that, let's get going. New DNR rules, effective as of December 14, 2016. Definitions. What's a new rule without new definitions? Common management. We're going to talk more about this later. I have several slides on what common management is, and this is used, one of the factors used to determine what is one operation or two. we'll get into those details. Keep this in mind. The term person was replaced in the definition of common management with individual, as I state here in the slide anyway, to make it clear that one producer cannot use two legal entities to create separate management. Now that may be a bit of an overstatement, but that's why the term individual is inserted there. We'll talk about that more when we get, it's in slide 30-something, I think. Another definition, complete application. I know one of the issues DNR struggles with, and producers do, when an application is submitted for a permit, manure management plan, and CD construction design statement if it's non-permitted site. What if it's not complete, and then does your time period start over if you have to submit more information? And I know DNR struggles with this. As I said, producers do too. There is now a definition of complete application in the rules, and it's one in which all questions have been completed, it's signed, and all applicable portions and attachments have been submitted. So therefore, if there's additional, if you've done that, but there's additional questions or something from the department, it shouldn't make your, if you've done these things, it shouldn't require you to start the clock over. And again, I'll start right out. Jeff or Gene, anything to add to this definition? I think this is kind of the way DNR was doing it in practice anyway, and now it's in the rules, so we have a better understanding, I believe. Public use area. This has been the subject of a lawsuit that has bounced from a district court judge up in Kossuth County for the last 3 years now. I think this lawsuit has been going on as to what is a public use area. Of course, public use areas have a separation distance required. The issue was a gravel pit that is arguably now a lake. I'll use the term arguably because that's part of the subject of the litigation, but it was whether it was on the, it wasn't on the list. Did it have to be on the list of lakes to be a public use area, or did it have to meet other requirements? The new rule, I think, has cleared all that up. And when it comes to a lake, to qualify as a facility where the public congregates and remains for significant periods of time, it has to have, and I've just put the things in there regarding the lakes, cabins, and there's swimming beaches were already in the rule, things like that. But this, the issue in this case was fishermen. This lake slash gravel pit, former gravel pit, was used for fishing, and the question was that, did that qualify as a public use area, etc. What the department and EPC have done in this rule is to put in the rule what they have to see to make a lake a public use area that qualifies for the separation distances as a public use area is there have to, from the fishing standpoint anyway, there have to be fishing docks, houses, fishing jetties, or fishing piers at lakes. Okay? So hopefully that'll help clarify that so we don't have another issue like that one or similar to that. Slide 3, manure on snow or frozen ground. Again, I've got a series of slides on this coming up right after these, but this rule restored, as I call it here, the exemption that expired in 2015 that allows confinement operations without enough manure storage to store from December 21 to April 1. Under normal circumstances, they can now once again use the emergency exemption. They have to meet the other requirements that we'll talk about. But these are generally for the older operations that don't have enough storage to get between those dates, often the smaller operations. And this amendment allows the exemption only for operations with no manure storage structures after May 26 of 2009. That's when the legislation was approved. So if you were in place as of that date, haven't changed anything, added any storage, and you can't get through the winter because you don't have enough storage, and you have to be subject to the rule, you have to be required to have a manure management plan, etc. But you can use the emergency exemption, but we'll talk about how you have to contact DNR, etc. Okay. Slide 4, expired construction permits, animal unit capacity. If you don't get your construction completed on a site where you have a permit within 4 years after the permit is issued. The rule now makes it clear DNR will amend your permit and reduce your permit by the capacity that you didn't use. More or less, I think, a paperwork issue. Beginning construction. What is it? The rule prior to this amendment said it's pretty much excavation is where you first reach that. Why is it important? If you need a construction permit, you cannot begin construction until you have that permit. Often people wanted to do some work ahead of time if they were waiting on the permit, depending on the time of year. And previously you could do leveling, site compaction, that kind of thing, as long as you didn't do excavation. Well, the rule has been changed to state that filling or compacting soil or soil amendments is now considered also to be beginning construction. So if you have a pending construction permit, you can still do soil leveling, but now bringing in fill dirt or compacting is added to excavation as something you can't do until you have a permit. Okay? We've had some questions about that this fall. The rule went into effect December 14th. So from here on out, again, you can't do those activities until you have a permit. On the other side, and I don't have this on the slide, the rules state that you have to, if you get a permit, that you have to begin construction within 1 year. Okay? You have 4 years to complete it, but you have to begin construction on that permit within 1 year. Well, and sometimes producers don't get that done. Most of the time the calls I get are when they're ready to go right now, so it's not usually an issue. But if you have that permit and aren't actually going to start quote-unquote building for a year, you need to get construction begun within a year to keep your permit. So now bringing in fill dirt or compacting would qualify as beginning construction, so that should get you, again, get your foot in the door to keep your permit. Any questions on any of this? Okay. All right, earth and secondary containment, dry manure. This is an issue that Kent Maurer and I worked on several years ago, and I know it's come up before. These are dry manure confinements, often cattle, but can be hog also. And if you're too close to a creek for the separation distance, you need secondary containment. If you're a liquid site, the secondary containment is pretty involved. You need meet percolation standards. Usually you would have to have an engineer involved, et cetera, to design that secondary containment. Dry manure, the rule has been changed. Clarified maybe a way to say it, that for dry manure confinements that are going to build too close to a creek for the separation distance, to get that exemption now, that secondary containment not required to meet the percolation standards and dike slope and width and all that are required for liquid. And it is required, though, that for this secondary containment, if there's any dry manure that is in that secondary containment area, that it be removed within 14 days so that it doesn't become liquid manure, I guess is the best way to say it. Okay, so if you're working with dry-bedded cattle confinements or hog dry, this is all dry, not liquid, these operations don't have to meet this I'll call them stringent requirements for secondary containment. Slide 7, measurement of separation distances. You know, I've been doing this work with DNR rules for about 25 years now, and it never ceases to amaze me how sometimes inches matter. Well, that may be an overstatement. Feet matter. One of the first calls I got back in the mid-90s when this law went into effect and this measuring separation distances was from a producer who said, "Do I have to count the overhang on the building?" And I said, well, how about getting that building a little bit further away if you haven't built it yet, so we don't have to worry about overhang? But I understand that sometimes these issues come up, and I know the department deals with this. There was some question under the department rules whether in a confinement building, did you count the areas to measure the separation distance? Did you have to measure from the areas that didn't have pigs or manure in them? Did you have to make, if there was an office on the end of the building, what about the bulk bins? What about the loading chute? Where did you measure from? This rule clarifies that you measure when measuring to the neighbor's residence, to a creek, whatever it is. When you measure from that confinement structure, you measure only from the areas that store manure or house animals or litter, and you don't count offices, loading chutes, bulk feed bins, etc. Okay? Gene or Jeff, if you have anything you want to chime in, why, don't be bashful, okay? Okay, separation distance waivers. Again, I'm going to talk more about these later, but the rule was amended that these waivers now, if you're, first of all, they have to be specific to the construction or expansion in which the application is submitted. So what we're looking at here, folks, is for future construction or expansion. And if you need a waiver from the neighbor, primarily that's what we deal with our residences, to build your confinement building. If it's too close to that neighbor and the neighbor says, sure, I'll sign a waiver, sometimes the producer and those that are working with the producer will say, well, you may want to add another building in the future. And why don't we have that waiver apply to that future building so that you don't have to go back to the neighbor and bother them again with getting another waiver? That's fine. But the rule now says that waiver has to be specific. That second bullet point there in the slide, future expansion is only included in the waiver if the waiver includes specific language describing the future construction or expansion. So in other words, for DNR purposes, you can't have a waiver that says, I grant a waiver for the building that's being built in all future expansion. That's just open-ended. It has to describe it. And so that, I think in essence, so that that person signing that waiver knows exactly what, one, you're going to build right now, and two, what your plans are to build in the future. And if you describe it that way, then it meets the rule, and then when you do build in the future, you wouldn't have to get another waiver. Okay? All right, concrete standards. Form ties in concrete wall construction and conduits or pipes that go through an outside wall cannot be below the ties have to be non-removable, and the pipes can't be below the maximum liquid level of the structure. I think most, or many, if not most builders were doing that, but the rule now requires it and makes it clear. Soil sampling. The requirement to sample once every 4 years for the P-index is replaced with the requirement the sample must be 4 years old or less. And for a new MMP, if the samples that are submitted with the original MMP don't meet the minimum acres per sample requirement, which is allowed when you have to submit the samples that do meet the minimum acreage requirement, you are to submit a new MMP with that. Okay? Earthen basins now can, with both open feedlot effluent and confinement manure, must meet the confinement construction standards. There had been some question there. And then the list of lakes that I mentioned for public use areas, this list is used for the major water source separation distance. That list has been added to. So if you're working with those separation distances from major water sources, that list has been, I think, significantly expanded as to which lakes are on that list. So take a look at that. Excuse me. Okay, moving to open feedlots, primarily cattle here, I guess. Chapter 200A, which is a chapter in the Iowa Code that has allowed for, since 1998, confinements that have dry manure can register their manure with the Iowa Department of Agriculture under this Chapter 200A to be sold, and that is your manure management plan. I'm on slide 12 here. And that was something that cattle open feedlots wanted to be able to do also with their dry manure from the scraped solids, et cetera, from their feedlot. The DNR rules did not specifically allow for it. Now the rule has been amended, and open feedlots can use Chapter 200A. You have to register with the Department of Agriculture. You get a certification, and then you file that as your nutrient management plan now for open feedlots. If you are using 200A to sell your dry manure, you register that, and that becomes your nutrient management plan for DNR purposes if you're over 1,000 head. you still would need, as I point out in the last bullet point, you still need a nutrient management plan for the liquid portion that doesn't qualify for 200A. Slide 13. Now we're into that last slide and this slide are the rules that were adopted to implement, put in the rules what's already in the Iowa Code. When the legislature changes the law, then we need to make the rules complete. We need to put those rules in the DNR rules, the administrative code, and then sometimes fill in some of the gaps in that legislation. And here's slide 13, 2012 legislation that excluded replacement gills from the animal units for swine, fern, and gestation operation. When you're looking at the aerobic treatment requirements, when you get up there big, I'll call it for farrowing units, and this legislation, it's been the law since 2012. It has now been put in the rules, so anyone reading the rules will know that is the law. Slide 14, 2013 legislation that allows a confinement operation to downsize to become a SAFO, small animal feeding operation, without rendering part of their facilities unusable. In 2013, when this bill passed in the legislature, it was called the mothball bill. If you want to mothball part of your operation that brings you down below the SAFO threshold so that you aren't required to have a manure management plan because you've dropped below the 500 animal units, but you didn't want to just tear down that part of the building or whatever you had to do to render it unusable, you can now do that and have been able to do that since 2013. This rule clarifies or expressly states that you don't need to file an updated manure management plan during that period that you're mothballed. But if you go back above, start using that part of your operation again, you need to then start filing a manure management plan again. And we've had several questions about this year, about having to file the updated MMP. And again, this rule clarifies you don't during the time you're mothballed. Again, that's legislation and a rule for the smaller operations. Truck washes. Anyone here with questions about truck washes, I'll be glad to talk to you afterwards. Probably won't spend much time on it here. Because it gets pretty detailed, but this 2015 legislation moved the regulation of livestock truck washes from the industrial permitting part of the DNR and DNR regulations into animal feeding. There's a specific chapter now for livestock truck washes and specific rules. I think if you are planning on building a truck wash or are working with one, these rules I think can be very helpful to simplify that process. All right, I probably won't cover 16. We're on to slide 17 now, where we're done with the new rules. Any question on the new rules I just covered? Again, I don't think anything real major there, but there are some changes that do affect people, obviously, with what we talked about. And if you have any questions, let me know, and we'll be glad to work through them with you. Again, we Iowa pork producers have put out a couple of things on the rules that have been changed, but again, I gave you a summary here today. Any questions? Okay. Manure application on snow or frozen ground. This has been in place since 2009. Want to go through a few things here. Hopefully you don't have to do it. Nobody wants to do it from either a nutrient preservation standpoint, I'll call it, keeping those nutrients where we want them available for the crop, water quality standpoint, etc. Plus, just, before I put the suit and tie on, I used to haul my share of manure in the wintertime, and it's just not a good time to do that. Better times of the year to do it. So, but if you have to do it, if you have what the rules call an emergency, the rules do allow for it, and we'll just run through it briefly here today. What doesn't this law apply to? It doesn't apply to manure from open feedlots. It applies to does not apply to dry manure, I should say, which is manure that can't be pumped and doesn't flow under pressure. Don't make the argument that if that manure is frozen, it can't be pumped or it doesn't move under pressure. It doesn't count if it's frozen. It's still liquid. If you're a SAFO, bullet point 3 there, this law does not apply to you, and it does not apply if you can inject or incorporate it. And in other words, it applies only to surface applications. So if it's in the winter, in these dates we're going to talk about, but you can still, the weather conditions, soil conditions allow you to inject or incorporate, then you can still do it. Okay. No surface application from a confinement with an MMP on snow-covered ground from December 21 to April 1, and frozen ground from February 1 to April 1. What is snow-covered ground? My last bullet point there, it's at least an inch of snow or a half an inch of ice. And what is frozen? Impermeable to soil moisture, does not include ground frozen only in the top 2 inches or less. That's the definition of what is frozen or snow-covered. Okay? Also, if one portion of the field is snow-covered and one portion of the field is not, you can apply on the portion that is not, if you're within those dates. It applies to those areas. And what is an emergency? You need to have an emergency before you can apply based on this law. If you are otherwise restricted, it is unforeseen circumstances beyond the producer's control. It includes, but is not limited to, natural disaster, unusual weather conditions, or equipment or structural failure. Unusual weather conditions, you couldn't get it on in the fall. We'll talk about that for a minute. And then equipment or structural failure, usually we're talking about a broken water line here. Fills your pit up and you just can't make it past April 1. You need to get it pumped out. So what do? You contact the DNR. You have to give this information. And I guess what I will say, and I don't know if Gene or Jeff will have any comment here, but you need to have a legitimate and verifiable reason why you didn't get it put on last fall. Unusual weather conditions, I think it depends on your individual circumstances, etc. But DNR requires verification that what steps did you take when you last fall to get it put on. We had some pretty good weather last fall. I think what we're usually looking at in unusual weather conditions is a fall like we haven't had for several years, where you just plain can't get it on. Rains and rains and rains. You were lucky to get the crop out, etc. Again, DNR will require some information verifiable that you just plain couldn't get it on because of weather or equipment or structural failure. Guys, anything to add what I just said? I guess what I'm trying to say is it's just not a matter of calling DNR and saying unusual weather conditions, I need to pump. This is, pumping on frozen or snow-covered ground is a critical issue. That's why we have a law about it. The law is there to allow you to do it if you absolutely have to, but it's not there to allow you to do it just by doing it because you plain didn't get around to it. So in the fall, for instance, this year in certain parts of the state, we know we had flooding. And we were ready at Iowa Pork to be ready, to try and work with producers if they had to use this law. But luckily, I think the weather turned around and you were able to get the manure applied, which is the best thing for everyone if we can do that. Okay. I'll probably skip. Well, slide 21 is where I talk about the smaller operations, the older operations with the exemption for if they just don't have enough manure storage. Those operations need to contact DNR, as I talked about, explain it, and get the approval to apply during the winter. And again, that exemption is now once again available to producers. Other things to think about, consider, all manure must be applied. I'm on slide 22. Must be applied so as to not cause water pollution. So if you qualify, you follow all the requirements for applying on frozen or snow-covered ground as an emergency. You still have to meet that requirement. You cannot cause pollution. Are you complying with any equipment requirements if you receive that to build your facility? What about your MPDS permit if you're a combination feedlot? If open and confinement, if the operation has a master matrix, look at the points if you took for injection or incorporation. You'll need to work through that with DNR and obtain written approval from DNR. And I guess my point is, it's contact DNR as soon as possible for assistance, even if not required by the law. Even if you're a SAFO, I suggest you contact DNR. That way, if they get a phone call from your neighbors that says, hey, so-and-so's out there applying manure on snow, I thought there was a law against that, DNR will have already heard from you, and you will have told them, and they will be able to say, yes, but here's the exemption, or they have applied and received emergency approval, etc. Okay? All right. Now we're into the work plan assessment, slide 23. As we all know, here in 2013, DNR and the federal EPA entered into a work plan where DNR was to do quite a few things, but one of the major things required under that work plan was for DNR to conduct assessments and inspections of pretty much every animal feeding operation, at least above 300 animal units in the state of Iowa over the next 5 years in 2013. And this is where I'm going to call on Gene or Jeff. Gene, as I understand it, you're well over halfway, right? Jeff? Yeah, the answer is yes. We'll move through here some of the requirements of these assessments. A lot of this is repeat, but just to show of hands, how many, and Gene and Jeff will close their eyes, how many here have been inspected already under these work plans? So just gauging about half of you, if that's a fair representation of operations. As I looked at the last report that DNR made to EPA, is my understanding you're well over halfway. But also we are identifying, you're now in the process, DNR is in the process of identifying some of the smaller operations that you were required to do by the work plan, and that process is going to take a couple of years, right? Jeff nodded yes. My experience, what I've seen there, I have been contacted a couple of times by producers. One contact was a producer who does not have, I think he just has cow-calf, has a building there, and Jeff or Gene, help me out here. I don't want to say anything that's wrong, but DNR is looking at sometimes county assessor records, et cetera, to try and determine what is a livestock operation. And Jeff is nodding yes, and then taking that information and sending that producer a letter. Is that right? And that letter just asks for more information as to what do you do, what do you have there. And if you're not an animal feeding operation, that's the end of it. If you are, then they'll ask for more information. Is that correct? So EPA required DNR to do this. I know this letter causes some people concern when they get it. You know, what did I do wrong? Am I in trouble now? Basically, it's a letter asking for information. If you provide that information, it doesn't mean you're in trouble. It just means DNR is looking for animal feeding operations that aren't that don't have a manure management plan or a permit. Otherwise, they'd know about them. And so that's their process, again, as required by the work plan and EPA. Any questions about that process that DNR is using? Okay. Let's see, did I cover everything? This slide 23 talks about desktop assessments. DNR, prior to doing an on-site inspection, will conduct a desktop assessment using publicly available information and then use that to determine if they're going to do an on-site inspection. Slide 24 is where the work plan prioritizes their inspections. And I think my understanding is, and this I should have numbered these instead of bullet points, but as I understand it, we're pretty much down into the last 2 bullet points in most field offices. Either the large confinements, that would be the large CAFO confinements, those that have a permit, and then or the medium-sized confinements, and those would be in the category of needing a manure management plan from 500 to 1,000 animal units. That's pretty much where DNR is now in their inspections. They've worked through, I think, most of the open feed lots, the combination lots, and quite a few of the larger confinements. So I think when I stood here 2 years ago, maybe 3 years ago when we first talked about this, I said to the you know, the 2,400 finishing units, et cetera, out there in between the 500 and 1,000, I said, well, unless you've had a spill or a problem with DNR, you're probably down the list a ways. Well, folks, we're down the list a ways. So you're probably on the list to be inspected here at some point. So please, we'll talk about what to be ready for. I guess what I will say based on the calls I get, and, you know, people don't usually call Attorney Eldon McAfee and say, "Hey, Eldon, everything's going fine. Just wanted to let you know." Based on the calls I get very few calls about DNR work plan inspections. So everything must be going pretty well, which is good for everyone. I know we have some of you here that are in businesses that help producers with these inspections and go out on those. If you have any thoughts here, let me know. We'll talk about how the inspections go here in a minute. But I think generally this process, what I would say, being involved in this on behalf of the Iowa Pork Producers Association and Iowa Cattlemen's Association 3 years ago when this process was developed, we all had a lot of concerns, I think including the DNR. I think the process has went very, very well, again, based on my perspective. Hopefully we can get through it and get these inspections done and move on. I'm going to skip over some of the slides here unless anybody has any questions about when an on-site inspection is required. We've talked about this in previous years. I'm on slide 28. If you've had a discharge, unfortunate event to have a discharge, an inspection was required. But I note here that if you previously had an accidental discharge, no NPDES permit is required if you've corrected those conditions. That's just kind of a side note there. I'm on slide 29 now. Here's kind of the process. DNR will contact the producer 1 to 3 days before the inspection. My experience is they'll contact you well in advance of that. You have your MMP and other records available. Key point, I emphasize this every year, DNR will not enter confinement buildings, and DNR must follow the producer's standard biosecurity policy. Jeff, I assume you asked when you called, what's your policy? They tell you what it is, and then you follow it. And I say this every year, and I'll say it again. Your standard biosecurity policy cannot be that DNR is not allowed on site, okay? I haven't written that into any policy I've worked on, and anyway, I say that obviously tongue-in-cheek again. I think DNR has been very careful about biosecurity. Slide 30. Here's where I kind of get on my soapbox a little bit. The DNR inspection, as it says here, in addition to NPDES permit requirements, which is the primary purpose of it, is to determine if that operation is discharging and would require a permit for discharging, not a construction permit for discharging. It may cover other areas, and we've had a few examples of where producers haven't been in complete compliance with other requirements of the rules, and that was discovered during the on-site inspection. My advice to producers, when if you haven't been inspected yet or notified, because not all sites get on-site inspections, it may not be necessary. The desktop assessment may take care of it. But my advice is do your own environmental audit, check for compliance, give the coalition a call. As to what rules are required for your operation, check with us, check with your consultant. If you determine, wait a minute, I don't think I'm in compliance here, I haven't been inspected yet, there is a procedure under Iowa laws, slide 31, one of my favorite parts of the Iowa law, because it is something that allows you as a producer, if you determine, whoa, I'm not in compliance, I need to fix that, you can submit a notice to DNR called a notice of self-audit that you are conducting a self-audit of your operation. And also you can then, if you determine there is a violation, you can submit a separate notice that says, I've determined I have a violation, here's what the violation is, and here's how I'm going to fix it. And if you do that, there will be no penalties, and you'll be in complete compliance, and you move on. Let me know if you have any questions. In fact, I do have a few handouts up front here in the table that gives more detail we have in our environmental handbook that's on the website at iowapork.org. But I have a few handouts that goes through that environmental audit process in a little more detail. Afterwards, feel free to come up here and I'll show you where they are. Any questions on that? Okay. When you're notified of an inspection, I advise producers to ask for a copy of the desktop assessment before they come out and do the on-site, and make sure DNR understands whether you've had a previous on-site inspection. I didn't really go through that slide, but if you've had a previous on-site inspection, let DNR know about that, so maybe you won't have to have an on-site inspection, and then inform them of your biosecurity policy, and then contact your consultant, etc. During the inspections, DNR is to review your MMP and other records, ask about the maximum number of head confined at any one time over the last 12 months, and then the actual inspection. And, you know, as again, I give this talk every year and sometimes more frequently in between Pork Congress sessions, and I'm probably the last person who should talk about what they do during inspection because I've never been on one. So, but my understanding and what the work plan says is they will look at the manure storage structures, any manure stockpiles. If you're a dry operation, check for perimeter tile and an inspection port and outlet, feed storage, mortality handling areas, and composting areas downhill of the CFO of the confinement. I'm sure they'll walk around the whole operation, but focus on downhill because we know that stuff doesn't run uphill. And discharges, and there'll be, if there are any, which I don't think we've run into too many of those, but there will be photos and samples. And one point I need to make, and I did get some questions early on where, boy, they're taking a lot of pictures. Does that mean I have a problem? And I don't think, and Jeff, you correct me if I'm wrong, that doesn't necessarily mean that. It means they're documenting that you don't have a problem. Would that be correct? Yeah. So the fact that there are a lot of photos, if that occurs, don't think you have a problem. I'll just ask, anybody here who's been on more inspections than I have, anything I've missed at what they look for? Jeff or Gene? Covered it? Okay. Boy, quiet bunch today. I got to get some controversy going here to get some discussion going. All right. I usually manage to do that before I'm done. Okay. And then there will be slide 34. There will be a letter that comes out, document whether a discharge was occurring. Again, I don't think we've had many issues with that at all with the confinement operations because state law doesn't allow you to discharge. And the letter will lay out recommendations and or any legal requirements. And then there will be a regulatory status form in that letter. Okay? Any questions about the work plan inspections? All right. Separation distance waivers, slide 35. I know if you don't deal with these, then this doesn't hit home. But if you are a consultant that works with submitting construction permit applications or construction design statements and MMPs for the less than 1,000 animal unit sites, and if there's a neighbor that's too close, because that does not meet the separation distances, first of all, make sure they don't meet the separation distance. Keep in mind there's the grandfather clause for existing sites that allows them to use, if they're expanding, they get to use the separation distances that were in effect at the time they first built, and there's 3 different tables in the Iowa DNR rules for separation distances. So number one, make sure that they don't meet the separation distance, and if they don't, then if the neighbor will sign it, why you can get a waiver to allow you to build even though you don't meet the separation distances. As I point out on slide 35, it must be signed by it's the title holder of the land where the residence is located, the title holder of the land where the CFO structure is located. It's under such terms and conditions that the parties negotiate. These are right in the law. That's also then in DNR rules. We talked about the new rule on future expansion, okay? Those terms and conditions, as we talked about, if there's a waiver is going to cover future expansion, you have to specifically describe that future expansion. and it must be recorded with the county recorder where the residence, etc., is located. Okay? Other issues, and this is where I see some of the problems with these waivers. Make sure it is properly notarized. To be recorded, it has to be properly notarized. What do I mean by properly notarized? Any of you in here are notaries? Okay. Well, I am. And one of the requirements to notarize somebody's signature is that person is in front of you and signs in front of you. Okay? If somebody tells you it's okay to take that waiver, have the neighbor sign it, and they really don't want to have to go to town and go to the bank or go to a lawyer's office, that they can just sign it and you or someone else can take it into town to the notary and tell the notary, yes, they signed it. No, that doesn't work. Now, will the county recorder take it? Probably, because they don't know any different. But if you're ever challenged on that waiver, that is not properly notarized, and the notary gets in trouble. Secondly, can that person who's going to notarize it call the person who signed it and say, did you sign this? They can do that, but that doesn't meet the requirements of the notary law. That person signing that waiver that is having their signature notarized must appear in front of the notary and sign it in front of the notary. Okay? That is one step. Do not cut corners on. You may be okay, but if ever challenged, you got a problem, and that notary has a problem. Okay? Verify the legal descriptions and legal ownership. You would be surprised, or maybe you wouldn't, how many people really don't understand how they own their land. They don't realize, oh, wait a minute, I put it in a revocable trust, or what? They just, or again, I guess it's a good problem to have, but many people don't understand how they actually hold title. If you're doing these waivers, verify title, verify who actually owns that residence, and make sure those are the people who signed the waiver. Legal descriptions, you can get those on the internet. Yes, you can get them from the assessor's website, etc. I urge you, it sounds like I'm making a pitch here for lawyers to get business, don't I? I assure you, at least I have plenty to do. We do waivers, but my only point is, it's one of those Pennzoil speeches. Remember that commercial where Pennzoil said, pay me now or pay me later? You can save some money up front by on these waivers, maybe by getting some of the information without going through an attorney. That's fine. You might be okay, but you might also pay an attorney a heck of a lot more later if there's a problem and it wasn't done correctly. I'm just saying, again, verify legal descriptions, get the legal description. The best way is to have the abstract continued, but that I usually don't go that route. We verify the legal descriptions with the county recorder with the last recorded document, something we would call a title search, and then also verify ownership. I think, again, as I said before, nobody calls me and says, hey, it worked fine, just wanted to let you know. I get called when there's a problem, so I'm a little sensitive to what those problems can be. Consider a nuisance covenant. This is my last point. This is not a DNR issue, okay? But I have seen where a person, a neighbor owning a residence, has signed a waiver and then a few years later threatened and a nuisance lawsuit saying, well, I know I signed a waiver allowing you to build it, but boy, it stinks a lot worse than I ever thought it would. And, some neighbors don't want to sign it with a nuisance. You can put a covenant in there where they agree not to bring a nuisance action for odor, et cetera. And some say, my clients, the livestock producers say, well, I'm not worried about it. Okay, that's your decision. That's the neighbor's decision, et cetera. But if you have any concern at all, I'd certainly look into having that part of the nuisance, part of the separation distance waiver, which you can do and we have done. Again, a very important document, because once you build that building there, they don't move very easy. And if the neighbor starts complaining about having signed a waiver, again, it can be very stressful and time-consuming and expensive. Yes, sir.
What if that neighbor that signed the waiver sells their house, somebody else moves in, and they want to go ahead and have legal action against that producer because of the smell?
Okay. And again, I'm going to repeat your question for our web version here. Question was, and I never say it exactly the same, but question was, waiver is signed, everything's fine, but then the owner of the residence who signed the waiver sells the house, and it had a nuisance covenant in it, and whoever buys it then says, well, I didn't sign that. Now, you didn't say it exactly that way, but that's what, that's what, here's the way I put it, and now you have a lawyer here now stammering a little bit. You noticed that, didn't you? First of all, it's very clear the person who signed it is subject to it. As it goes down the chain, not quite as clear, but that person who bought that property, see, that waiver goes in the abstract, the chain of title. So they bought it with full knowledge of that waiver. I believe that is effective against the neighbor who the person who buys from the person who signed the waiver, because they were fully aware of it and bought it knowing that. Obviously, you don't have to move your building. The other thing that helps you as the producer in that case, nuisance lawsuits are founded. One of the factors in a nuisance lawsuit is who was there first. So when that neighbor buys from the person who signed the waiver, your operation is already there, and now you may change it or something, but they are aware. They already have. They're down the rung of the ladder away, or down a rung of the ladder a ways, because your operation is already there as a matter of nuisance law. So several things going for you there. I believe it is effective. But good question.
In that same kind of, you owned the home that was too close to you didn't need a separation waiver because you owned the home. Mm-hmm. And you sell it to, say, a son or a relative, should you put in there a nuisance covenant and a waiver so that whoever's ever buying that place, even though they can see that building there and know it's there, because heaven forbid a divorce or death and it gets sold again, you see where I'm going, right?
This is the part where we get to you're saying, we got an attorney standing up there. He's going to earn his keep here, right? All right. Well, first of all, this is not a DNR issue, because once the building is built and whoever was living in the residence at the time signed it, then that allows the building to be built. Okay, so it's not a separation. I'll get to that. I'm doing what a lot of attorneys do. I'm answering it the way I want to. Okay? But seriously, and I didn't repeat your question for the web version here. Your question is, again, didn't need a waiver because DNR requires a waiver of a separation distance if different parties own the livestock operation and the residence. Later, so at the time you built, they were the same, which did not require a DNR waiver. Fine. But then later you sell the house. Okay? So my first answer to that is you don't need a waiver now when you sell it because the building's already there. Not a DNR issue. They're out of it, at least in my analysis. Your question, though, is that person buying it, do I need something to say they aren't going to sue me? I haven't done one that way. I'm not saying you couldn't. You could require, first of all, are you the one selling the house? Okay, I have done those where the person owning the livestock operation also owns the house, and before they sell the house, you put a covenant, a nuisance covenant that they won't sue you for nuisance, and you put it right in the deed. Okay, but you don't need a separation distance waiver there in mind. So that's how you would handle that. You also have going for you that your operation is already there, and they're moving in knowing it's there. Okay? All right. Did I answer your question? Okay. Again, you handle that through the deed, not necessarily through a separation distance waiver. Okay. In fact, that is one, I think I still have that on my list of for nuisance lawsuits is if you're concerned about a neighbor's house and it comes up for sale and you say, well, I really don't want to own another house, maybe you do. And then you turn around and sell it, but put a covenant in the deed that they aren't going to sue you for nuisance. Okay. All right. Glad we spent some time there because, again, I've been through a few skirmishes lately on these waivers, and they're not fun. Okay, animal capacity. As usual, I thought this morning, I might get done early. Never happens. Sorry. We'll kick it up a notch here because it's 10:15, and I don't want to keep you late for anything else here. And I haven't even got to lawsuits, but we'll get done here. Animal capacity, animal weight capacity. I'm going to skip over quite a bit of this just to point out slide 39, how to calculate animal unit capacity. It is not an average or whatever of the pigs, etc. It's a calculation is based on the number of pigs weighing more than 55 pounds and the number weighing 55 pounds or less. There is a calculation you can do, and as I note here, the safest approach is to, like if you're overstocking at all, the safest approach is to remove those pigs before any weigh more than 55 pounds, because that's where it kicks back here on slide 37. It changes from 0.1 to 0.4. But that's not, whoops, went wrong way, sorry. That's not actually required by the law. You can have some more than 55 pounds and still be in compliance, and that is on slide 40. If you're double stocking a 2,400 head site, the math works out as we have it here, where there's a factor you can apply of 0.33. Again, I'll let you work through that. I've talked about it in previous years. If you have this question on overstocking, double stocking, staying in compliance with your animal unit capacity, let us know. I actually have a separate slide presentation on that we spend about 45 minutes on sometimes. Critical issue to stay in compliance, but again, if many of you have been through that and know what you need to do to comply. And what I always say, it's easy for a lawyer to stand at a podium in Des Moines, Iowa, and tell you how to when to get your pigs out of those buildings, right? I'm not the one that has to manage pig flows, et cetera, but that's what the law requires. Slide 41, options other than reducing capacities. If you are over capacity, we lay out what you need to do as far as modifying your permit, et cetera. Any questions on that? Okay, one operation or two. We've talked about this many times in previous years. I'll cover it briefly here. If you're adjacent, which means within 1,250 feet or 2,500 feet, if you own or manage two sites and they're more than 2,500 feet apart, you're fine. You can't be combined, but if you're closer than that, then you have to have separate ownership or separate management, okay? If the two sites add up to less than 1,000 animal units, they have to be at least 1,250 feet apart. This is the bottom slide 42. If they add up to more than 20 or more than 1,000, they have to be at least 2,500 feet apart, okay? Critical issue. It has been in the news for separation distance purposes to determine to the neighbor's house. We have a different set of distances for adjacency. I won't go through those here. Those are not as strict as the ones on the previous slide. If you comply with those, you comply with these. What is common ownership? It's, if you own them both, that's clear. If you're in an LLC, corporation, et cetera, it's a majority ownership interest, and the majority ownership interest is common when it is held directly or indirectly through a spouse or dependent child. So, again, we could have a lot of discussion here on both of these issues. What is common management? This means a significant control by an individual of the management of the day-to-day operations. Tells you a lot, right? Everything you need to know. I'm tongue-in-cheek. Common management does not include owning the pigs, the one owner of the pigs in the two different sites. That was removed in 2010 by rule. So ownership of the pigs doesn't matter. It's the control over the operation. All right. Take a look at slides 46 and 47. What is common management, and what does DNR look at to determine if there's common management? I took this right out of a DNR letter that one of my clients received, And these are questions that DNR asked. Who controls day-to-day decisions regarding animal management? Who decides when and for what reason to contact a veterinarian? Who makes adjustments to feed rations, water, etc.? And folks, understand that you can answer that the owner of the pigs makes those decisions for both of those sites, because that doesn't mean it's common management, okay? Ownership by them and their management does not make, as long as you're controlling the day-to-day operations, they can control these things that are normally controlled in a contract, okay? Who is in charge of the daily management and maintenance? That's a key issue. If there's separate management, that better be one person doing it on one site and the other person doing it on the other site. Next slide. 47, who owns or pays for utilities, contracts for manure applicators, and who signed on to the contract. These are questions that DNR has asked of producers when there was a question about common ownership and management. Any questions about those? Just, if you're dealing with that issue, circle those slides 46, 47, and also the definitions. Okay, done with DNR issues. I've got 10 minutes left, and we'll get through it. Whoops. Yeah. Okay, slide 48. Now we're into lawsuits. Near and dear to every attorney's heart, right? Okay, and why you're here listening to me and hopefully to stay out of them. The Des Moines Waterworks lawsuit, you know, since we were here a year ago, not much has happened. We're waiting on a decision from, and slide 49, waiting on a decision from the Iowa Supreme Court to really determine, can drainage districts be sued for what the Des Moines Waterworks is suing them over. Believe me, I have greatly simplified that, but I lay it out on slide 49 what those questions are in front of the Iowa Supreme Court. Oral arguments were held in September and are waiting for a decision from the Iowa Supreme Court any day. Stay tuned. I'm sure all the media will pick up on this. This will be one decision that will get a lot of attention from everyone, and you will hear about it as soon as it comes out. If the Supreme Court could rule that no, drainage districts, this is not a proper lawsuit against drainage districts, case could be over. If they rule it is, then it goes back to the federal court, and the federal court will then pick it up. And the trial is set for June of 2017. We'll see if that trial, it's still on schedule for trial, but then the trial would be about the real issues in the lawsuit, and that's whether drainage districts are required to have an NPDES permit, okay? And that is whether they are a point source. I lay that out on slide 50. Again, if you have any questions about the Des Moines Waterworks lawsuit, feel free to let me know, but it's all waiting on that decision from the Iowa Supreme Court right now. Okay, nuisance cases, slide 52. I've allowed 10 minutes for this here, partly by design and partly by we had other stuff to talk about that I thought was more time sensitive. I'm not downplaying ag nuisance cases. They are a critical part of a threat, a risk of our operations out there. But as we stand here today, we've seen many cases in the state of Iowa that have been dismissed. Several have been decided in the last couple of years and have been favorable to the producer. One was decided and affirmed on appeal by the Iowa Appeals Court that was not favorable to the producer. So I want to go through here. We have 7 cases currently on file in the state of Iowa. I think when I was here a year ago, we had 15, something like that. But a few years before that, we had maybe 2 or 3, if I remember right. Still a critical issue. We're seeing the facts speak for themselves. We have fewer cases on file now than we did before. As I said, some of those have been dismissed. They can be refiled. In Iowa, if a person bringing a lawsuit voluntarily dismisses the lawsuit, they can do that once and still refile it. Remains to be seen if some of these cases will be refiled. We haven't had any new cases filed for some time now. When we get to the list, I'll be able to confirm. I don't know that any new cases were filed this past year. I need to double check that. Anyway, slide 52. What are they about? Odor and flies. It's the unreasonable interference with use and enjoyment of property. We talk about the normal person standard. Nuisance cases are based on what a reasonable person living in the locality would consider a nuisance. That is a key issue for the livestock producer. Another key issue is who was first in time. Who was the first one there? And I've been representing producers in neg nuisance cases for about 25 years now, and I've had one case in all those years, and I'm aware of one case in all those years where the producer was there first. Normally, if the producer was there first, the case doesn't get filed. But it is a critical issue the courts look at, that if the neighbor was there, the livestock operation was built or expanded after the neighbor was there, then you lose your being first in time status, okay? Fact witnesses are critical to any case, and they are especially critical to nuisance cases. The last category there, independent third parties. The cases we've seen in Iowa and a recent case in the last year in Illinois, the people living in the area that are not suing, that are not plaintiffs, they are critical witnesses for the livestock producer. They are critical if they will testify that, well, I live there, I notice odor sometimes, not a problem for me. That appears to be very critical to juries to hear that testimony. Okay, so I'm just telling you what the lawsuits the experience we've had. We'll talk about those cases here in a minute. Expert witnesses. I'll get myself into trouble for saying this, but I'm going to say it. Expert witnesses are like attorneys. Everybody needs one, right? So, okay. And I work with a lot of good ones, okay? Fact witnesses are the key. That's what juries like to hear. The people who, it's the truth. They want to hear what people experience who live there. And that's where I think what these cases boil down to. Okay, slide 53. One ag nuisance case went to trial in 2015, so 2 years ago. It was in Powesheik County. And the jury, after hearing all the evidence, where it was a 2,490 head finishing site, one plaintiff, 1,000 feet northeast, the jury returned a verdict on February 4th of $525,000. It was $400,000 for personal damages and $125,000 in loss in property value. Post-trial motions, the court cut that in half for the loss in property value, or $62,500, because the property was owned jointly and the husband was not part of the lawsuit. So the judge ruled you don't get the full $125,000, you get half of that. Still a lot of money. On appeal, and this decision just came out in November of this year, after appeal, the Iowa Court of Appeals upheld the verdict and ruled that the nuisance defense was unconstitutional in this case because it was similar to the case in 2004 where it was first found unconstitutional, and the court ruled that the verdict was supported by the evidence presented at trial and that the amount of the damages was not excessive. Okay, so that concludes that case. When we were here a year ago, I'm pretty sure I told you there was a case coming up that was to start in February, right after Pork Congress a year ago in Wapello County. The case did go to trial, and on February 29th, it was pretty much a month-long trial. That jury, after that, on a 4,280 head swine finishing site in Wapello County, found no nuisance and awarded no damages. It was a defense verdict. A lot of interesting aspects to that case, but that's the essence of it. Very good case for the producer, for JBS, the owner of the pigs. After trial, the court ordered the plaintiffs to pay just short of $50,000, $48,666.61 for litigation costs and expenses, but that did not include attorney's fees. And before trial, there was a $60,000 offer to confess judgment on behalf of the contract grower, and that was accepted by the plaintiffs prior to trial. That's something that one of those, I'll call it one of those legal approaches, I'll call it. Yes, sir.
The suit that was found negligence, is that site empty now then?
Okay, your question is on, I'm going back to slide 53, where they were found, where the jury awarded the 460-some thousand. The question was, is that site empty? Did it have to be emptied? And the answer is no. That was an award of money damages. The site is, to my knowledge, is operating as it was before. The question is, can they be sued again? And they cannot be sued again by that person, who, the plaintiff who sued them. It's over. They cannot sue again. Okay? Yes, ma'am. The question is, in the case on slide 54, JBS owned the pigs and they were being contract fed by the contract grower who owned the buildings. They both got sued. Okay. The question is, did the fact that JBS didn't, I think what you're asking is, they didn't own the buildings, nor did they take care of the pigs. Did that have an effect on the decision? We don't know with juries, but I'm sure it was a factor that the jury looked at. The question, I think what you're getting at is, was JBS responsible for the nuisance? And that evidence was presented to the jury that yes, they were. The plaintiffs alleged they were, by having their pigs there, and the jury found they were not. Okay? All right. Again, if there's, if you have any questions in more detail, I'll be around afterwards. I'll be here if you see me in the hall, or feel free to give me a call. I promise if you talk real fast, I won't charge you. Just kidding. Okay. All right. Slide 55. What do we have coming? Currently pending, set for trial. We have a case in Powesheet County against a swine finishing site set for trial May 20th. We have a case in Union County, cattle feed yard case. This is a different type of nuisance case. Odor has been alleged, but there's also some questions about runoff from the area where the cattle are kept, I'll call it, onto the neighbor's property. So a little different case. We also have a Louisa County swine finishing case trial in September, and then a Buchanan County cattle feed yard case. It was scheduled for trial last November, and then there was for a reason because of a case on appeal on the nuisance defense, this case was continued and postponed, and now it's set for trial in November of this year. Okay. Then we move into 2018. There's two cases, one in Henry County, one in Des Moines County, and then we have the Wapello County case that was supposed to go to trial in August, did not go to trial because it is now, there's a pre-trial appeal on the constitutionality of the nuisance defense, and that is now in front of the Iowa Supreme Court. Briefs were just finalized they were just filed yesterday. We'll see should be getting a decision from the Iowa Supreme Court. They're going to be looking at the nuisance defense again and whether it applies across the board or plaintiff by plaintiff, gets into some legal arguments there. The Iowa Pork Producers Association has filed an amicus brief in support of the producers there, along with the Iowa Farm Bureau Federation. Public record there. You can read the brief. If you're interested, let me know, and we'll get you copies of the briefs. And we'll be talking about the outcome of that case a year from now. A slide I always like to have is steps to help avoid a nuisance lawsuit. And I'm not going to go through these. It doesn't mean they're not important. I should have spent 10 minutes on these and less on the cases, because this is, folks, what I would ask you to take a close look at, to hopefully you won't be on that list. And I assure you that the producers who are on that list did many, if not all of these, but ended up getting sued. Not always. I guess my point is, don't quit trying. Do everything you can to avoid a nuisance lawsuit, but sometimes you can try all you can and you're in the wrong place maybe. Again, I'll leave that to your reading because I'm over my time. Location is always at the top of my list, separation, distance, prevailing winds, etc. And then overall management is also a key. Insurance, as I always say, I'm not selling it. There are people who are, and I'm pretty sure they're upstairs. Your standard farm liability policy does not cover nuisance actions. In most cases, if you have a concern about whether you're covered, have your insurance policy reviewed. If it doesn't cover it, there are policies available. You'll have to apply, et cetera. And again, talk to your local insurance agent about those policies that are available. If you can't find one, if your agent is not aware, let us know. Again, I'm pretty sure there are companies upstairs that are offering it. Stop by them, talk to them. Nuisance defense laws, we'll leave that discussion for another day. Finish up with, I have 3 slides on EPA air emissions reporting. Nothing has changed there from last year, but I always include this for those sites that are larger than 2,500 head. Take a look at that about what reports may be required. I see Gene's not in here now, but I always ask him, Jeff, you get these reports on some sites and some you don't, right? And you don't do anything with them other than receive them. Okay. All right. Environmental Regulations Handbook. It's on the Pork Producer website, as always. And if you go there right now to see a complete review and analysis of the new DNR rules, it's not there because I haven't got it done yet. Okay? So these slides are your best. We do have a summary we put out also of the new rules, but we'll get that changed, updated for the new rules. And we also on the website, the Environmental Regulations Handbook, I talked about separation distance waivers. We have an example there. I will put in an updated example for future expansion. And we also have a manure agreement there for you to take a look at. With that, I'm over my time. If you have a question, otherwise I'll be around and I'll be glad to take them. Excuse me. Thank you.